The corruption probe at City Hall is getting complicated. The state Supreme Court is now considering arguments over whether the grand jury's report on corruption in Hartford should stay sealed. This is a debate over how much the public has a right to know and the interest in confidentiality. With Mayor Eddie Perez and two others getting set for trial on bribery charges, the argument is that unsealing the grand jury report now, which might include new, different charges against them, would hurt their right to a fair trial. But Bill Fish, representing the Hartford Courant, which wants the full report released, points to case law, saying it's wrong to treat all of the public as potential jurors.
And to sanitize the information by not letting any of it get into the public when only a portion of that public is likely to be involved in the jury pool.
But the state is arguing that keeping the grand juror's report sealed balances the public's interest in disclosure with the public's interest in confidentiality. The investigation took 18 months. The grand juror interviewed 150 people. Clearly, there are people named in the report who haven't been charged yet and who might not ever be charged. Their attorneys say the report includes uncorroborated information that could nevertheless be damaging.
These are findings not by a police officer nor by a prosecutor, but by a judge. When a judge, as a grand juror, gives his opinion that there is probable cause to arrest my client, it raises the stakes to a new level in terms of prejudicing prospective jurors.
We don't publicize the results of an investigation where we didn't make an arrest, for example.
The Courant's attorney acknowledges there might be some aspects of the report that don't belong in the public domain, but he says certainly not all of it.
Whatever we're entitled to, whatever we are entitled to. And there are certainly sections of that report for which probable cause was found that we think we're entitled to see the report. And the public is entitled to see the report.
Joining me to tackle this complicated and nuanced question is Chris Marano, former chief state's attorney, and Chris Powell of the Journal-Inquirer. Chris, what kinds of information is contained in a grand jury's report? Are they often released?
Well, a grand jury report will sort of be a summary of all of the information that was sifted through by the grand juror during the course of the investigation. Many times they're released. Sometimes they are not released. If they're not released, there's a strict procedure by statute that needs to be followed for motions to be filed within a certain time period, and then objections are handled in the time period. All of that's been done here, and the grand juror made a decision based upon reference to the statute, and now our Supreme Court is looking at his decision.
What's your understanding of what the risk of releasing it is?
Well, basically you have to understand the history of the grand jury always had a secrecy or a confidentiality element. It is the earliest stage of a criminal investigation, and that's where rumors and innuendos and things that have no relevance are looked at to see if they substantiate a crime. So when it's done, that's supposedly sifted away, and just the meat that constitutes criminal activity goes forward. The stuff that's sifted away could involve activity of individuals who are innocent. And the process is to protect them, which goes along with our basic foundation of the presumption of innocence.
It kind of makes sense to me. Does it not to you, Chris?
No, those are good rules. We have similar exemption in our state freedom information law, Lori, for uncorroborated allegations. For example, the problem, however, is that unless the report is public, you really can't evaluate the prosecution. You can't evaluate the court itself. You can't really make a decision as to whether selective prosecution is involved. And in fact, I would argue that selective prosecution has entered into previous grand juries, particularly the grand jury we had in Connecticut investigating the Transportation Department scandal in 1980, where, for example, the Transportation Commissioner was under investigation. Art Powers said in testimony to that grand jury, which happened to come out by a fluke, that there were people at DOT who were getting 10 times the gifts that Powers himself had gotten. He was never asked to follow up on that. The chief state's attorney, Austin McGuigan, never asked him, okay, Art, who else got gifts?
So do you think, are you of the opinion that all of it should be released? There should be none that's redacted?
Well, not necessarily, Lori. I think it's just a difficult question. There's got to be some accountability to the public. On the other hand, if there is material damaging to innocent people or material that would compromise a continuing investigation, the court may just have to decide to withhold that part.
So, I mean, would that be up to the justices or up to the court, individual courts, to decide which information to release?
That's an interesting question, because what has occurred here is the grand juror has followed the statute and looked at the issues. In the statute, there are two areas. One says that if facts constituting criminal activity are not found on the actions of an individual, it does not get released, period. The second section lists 4 areas where it can be released unless it will cause problems. If it causes problems to a person getting a fair trial, it stays out. If it causes problems that might cause people to flee the jurisdiction, it stays sealed. If it causes problems that suborns perjury or tampers with witnesses, that stays out. And finally, if it will injure the lives or reputation of innocent people, that stayed sealed. And that's what this grand juror did. He looked at that and he made a decision. The question is, does the Supreme Court look to see whether he abused his discretion? And if they say he didn't abuse his discretion, they don't go any further, or will they re-look at the whole thing and make a decision?
I think my understanding when I was there this week at the Supreme Court listening to the arguments was that there was perhaps some leeway in terms of, okay, well then just release the elements that involve probable cause, or where probable cause has been determined. I mean, would that be sufficient, do you think, for your interests?
Well, it's going to be a judgment made by the court, and it's going to be a judgment made on the specifics. I mean, Chris has just spelled out the requirements of the law, and they're very reasonable. The problem is we, the public, can't second-guess them because the court is going to evaluate this essentially in secret.
But when you laid out those 4 elements to be considered, I thought, well, then they're not going to release any of it because, I mean, you could make the argument that any of the information might fit into any of those.
Well, the law recognizes that there is a need for things to come out. And it says in those 4 areas that the court has to, or the investigating grand juror has to look and examine alternative ways, such as redacting or things like that. And in the grand juror's decision, he said, look, I can't redact here because it's not going to take a rocket scientist, my words, not his, to put the pieces together and know who we're talking about. Alleging or dealing with assessing whether there are selective prosecutions or the concerns that Mr. Powell is raising, those will come out with a good cross-examination at trial further on down the road. This is the beginning of the process, and it's got a long way to go, and it may not be the end of the investigation. Just because the grand jury is done, that doesn't mean Mr. Kane and his office have to be done investigating using traditional methods.
Do you think that they are going to release any juicy details?
I suspect that the Supreme Court will stand behind the grand juror here unless he's really messed up.
Right. Right. How long traditionally would you expect that the justices would weigh on this?
I anticipate they took it rather quickly. I don't want to speak for anyone on the Supreme Court, but they know what's at stake here, and they'll do it in a responsible, reasonable time.
I would think that if there are arrests pending, wouldn't they want to get on that?
Well, they're not going to know that.
Right.
But there are, I believe, jury selection is scheduled in some of these cases in September, so decisions have to be made. It's an interesting collection of individuals objecting and not objecting, and it's going to be an interesting decision from the court.
Yes, definitely. Thank you so much, both of you, for coming today.